Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Four cases this week, most of them wins for non-citizens, and all of them interesting. And they're all over the place, so I'm going to just start with the 8th Circuit because we never do, and I feel bad about that. I also note that, and despite the urging of KKTP associate Elizabeth Montano, I will not be summarizing or discussing the 15 OCAHO decisions that EOIR seems to publish each week. I just won't do it, Liz. Finally, awesome news out of the 2nd Circuit in the FOIA lawsuit against the BIA. It looks like the BIA may soon have to make public every single unpublished decision since November 1996. More to come on this as this case proceeds at the district court level, and so stay tuned. But whoa. Here are this week's cases. First is Barahona v. Wilkinson, published by the 8th Circuit on February 3rd, 2021. This is a case about the serious non-political crime bar to asylum and withholding of removal. Mr. Barahona is from El Salvador and entered the United States without authorization. His wife was granted asylum in the U.S. based on a rape committed by MS-13 members due to her work in the Salvadoran prosecutor's office. And so, while in the U.S., she filed a Form I-730 petition with USCIS for her husband, Mr. Barahona. The I-730 petition, if approved, would allow Mr. Barahona to become a derivative asylee in the United States. USCIS, however, discovered an Interpol Red Notice against Mr. Barahona, issued by the country of El Salvador, requesting Mr. Barahona's arrest for allegedly being a hitman for MS-13, and participating in an illicit gathering in violation of Article 345 of the Salvadoran Penal Code. Now, the Department of Justice's official position is that Interpol Red Notices are unreliable and do not provide probable cause that a crime has been committed. Nevertheless, USCIS denied the I-730 and derivative asylum status based on the Red Notice, and so often occurs, ICE took Mr. Barahona into custody, based largely on this Red Notice. In immigration court, Mr. Barahona had to file his own principal asylum application because immigration judges lack jurisdiction to grant an I-730 derivative petition. That's a big deal, because now Mr. Barahona had to show that he warranted asylum and related relief based on his own set of facts. Plus, he's probably time-barred for asylum as a principal. Among other things, during his hearing, Mr. Barahona testified that MS-13 extorted him, forced him to rob a man, shot him when he refused to hurt the man, and then pinned the crime on Mr. Barahona. In the proceedings, DHS submitted what it asserted was an active Interpol Red Notice. And again, a Red Notice is essentially El Salvador's request through the international Interpol system for Mr. Barahona's arrest based on allegations of criminal activity. But a red notice is not an official extradition request, which would require a much more formal process in the United States. Possibly for that reason, countries often try to use the red notice and U.S. immigration system instead. Mr. Barahona presented evidence that the criminal charges against him referenced in that red notice had been dropped in El Salvador. The IJ held that the red notice provided, quote, serious reasons to believe, end quote, that Mr. Barahona committed a serious non-political crime in El Salvador. That finding bars asylum and withholding of removal relief under both relief statutes. The BIA affirmed, because if they didn't, we wouldn't be at the Eighth Circuit. And the Eighth Circuit reversed. It held that the BIA erred when the BIA and the IJ held that the red notice constituted, quote, some evidence to establish the mandatory bar, without a finding of probable cause, end quote. That is because under BIA precedent, the serious non-political crime bar to asylum and withholding of removal only applies if there exists probable cause to believe that the non-citizen committed a serious non-political crime abroad. Now, it's true that Mr. Barahona has the ultimate burden to establish relief eligibility. However, the regulations give DHS the initial burden, quote, to show that one or more mandatory bars to relief exists, end quote. And burdens aside, the Eighth Circuit seems to be holding that an IJ cannot ultimately find the serious non-political crime bar applicable absent evidence that equates to probable cause. For example, quote, in a case involving a red notice, courts have found probable cause was satisfied after the government submitted substantial evidence that petitioner committed manslaughter, which included the red notice, trial records, sentencing order, and letters from the chief of police in El Salvador, end quote. But according to the Eighth Circuit, no court has ever found a red notice alone sufficient. The Eighth Circuit distinguished this case from the BIA's 2017 decision in matter of MBC, which IJs and the BIA often rely upon for the proposition that DHS doesn't have an onerous burden to meet. And the Eighth Circuit distinguished because that case was about the genocide bar, not about the serious non-political crime bar, the latter of which expressly requires a serious reasons for believing standard, which again equates to probable cause. Although the Eighth Circuit dismissed Mr. Barahona's other arguments, it remanded for the BIA to make an appropriate probable cause finding on the serious non-political crime issue. Here's one more observation. No citation or discussion to the BIA's recent red notice decision in matter of WERB, wherein the BIA held that, quote, an Interpol Red Notice may constitute reliable evidence that indicates the serious non-political crime bar applies, end quote. However, I don't believe a discussion or a citation to matter of WERB is necessary, because A, obviously a red notice constitutes some evidence, and B, the Eighth Circuit wouldn't owe the BIA deference on such an evidentiary issue anyway. But it's good to have this Eighth Circuit decision in your pocket if and when DHS or an IJ wants to expansively rely upon matter of WERB, or for that matter, matter of MBC. And that is Barahona v. Wilkinson. Next, we have Tibakweitira v. Wilkinson, published by the Fifth Circuit on February 2nd, 2021. This is a case about withholding of removal, motions to reopen, and jurisdiction. Mr. Tibakweitira is from Tanzania and came to the U.S. in 1992 on a tourist visa. He overstayed, started a life in the U.S., and in 2015 pled guilty to conspiracy to commit wire fraud and aggravated identity theft. He received a nearly 5-year prison sentence and was ordered to pay $2.5 million in restitution. An IJ found that the conviction made him removable because it was an aggravated felony, and Mr. Tibakweitira applied for asylum and related relief, claiming that all those years ago he fled his forced conscription into the Tanzania Intelligence and Security Service, and that he'd be persecuted and tortured in Tanzania for this reason. The IJ's aggravated felony finding barred Mr. Tibakweitira from applying for asylum, as likely did his over 2-decade delay in filing his application. The aggravated felony, however, did not per se bar him from withholding of removal because he wasn't sentenced to at least 5 years imprisonment for the crime. But the IJ found that the crime was a particularly serious crime anyway, as immigration law allows an IJ to do. The BIA affirmed. The Fifth Circuit held that it lacked jurisdiction to review the particularly serious crime finding under INA Section 242A2C. That statute strips a court of jurisdiction from reviewing factual challenges to a final order of removal if the non-citizen has been convicted of certain crimes, including aggravated felonies. Here, the Fifth Circuit held that because Mr. Tibakweitira was challenging the IJ's weighing of evidence in the particularly serious crime analysis, that challenge was a factual question over which Section 242A2C stripped it of jurisdiction. That leaves deferral of removal under the Convention Against Torture. The Supreme Court's Nasrallah v. Barr decision last term provides that the Fifth Circuit retains jurisdiction to consider factual challenges to the denial of cat protection because the cat does not relate to a final order of removal. Rather, Convention Against Torture protection, by its very nature, withholds or defers a final order of removal. And so the jurisdiction stripping provision does not apply. So said the Supreme Court. So reviewing the cat issue, the Fifth Circuit upheld the BIA and the IJ, primarily because Mr. Tibakweitira did not present much evidence to support his claim, and because it's been so long since anything relevant allegedly happened to him in Tanzania. Turning to the motion to reopen challenge, the Fifth Circuit affirmed that denial too, holding that the new letters Mr. Tibakweitira wanted to present to the BIA and the IJ in support of his claim were neither previously unavailable at the time of the IJ hearing, nor were they material to his cat claim, as would be required to satisfy the motion to reopen standard. Finally, Mr. Tibakweitira argued that the BIA committed a due process violation when it decided his appeal through a single member, rather than through the more formal 3-member panel. The Fifth Circuit held that not only did it lack jurisdiction to review the argument because it was a purely discretionary decision by the BIA, but that the argument was meritless. So Mr. Tibakweitira therefore lost his case. One more thought. As I mentioned on the podcast when the Supreme Court published Nasrallah all those months ago, I see no principled reason why circuit courts shouldn't now also have jurisdiction to review factual findings related to withholding of removal under the INA, in addition to withholding of removal and deferral of removal under the CAT. After all, in all instances, an order of removal has been issued, which the non-citizen is requesting an IJ to either withhold or defer. The Nasrallah rationale, therefore, would seem to apply equally to withholding of removal under the INA. The Nasrallah court expressly left this question open for another day, and it doesn't appear that the issue was argued in this case. But maybe it should have. Maybe it would have provided a way for the Fifth Circuit to review the particularly serious crime finding. And that is Tibakweitira v. Wilkinson. Moving on, we have Martinez-Baez v. Wilkinson, published by the Seventh Circuit on February 1st, 2021. This was actually the first immigration decision published this week, and it's a pleasant one on cancellation of removal and credibility. Mr. Martinez-Baez is from Mexico and testified in immigration court that he first entered the United States unlawfully in 2000. DHS agrees that he must have, because they returned him to Mexico 3 times in June of 2000. Mr. Martinez-Baez, however, claimed that he last entered the U.S. during the summer of 2000 and that he never left. He bought fake papers and began working in Wisconsin. And he began to file tax returns with the IRS, by the way, as early as 2002. He had 3 U.S. citizen children, one of whom has speech and language impairments, requiring her elementary school placement in Wisconsin's IEP, or Individualized Educations Program. DHS found out about Mr. Martinez-Baez and served him with a notice to appear, dated April 1st, 2011. He was served with the notice of hearing shortly thereafter, and appeared for that hearing in June of 2012. He eventually applied for non-LPR cancellation under INA Section 240A-B, providing his own testimony and that of a speech pathologist at the elementary school to explain Mr. Martinez-Baez's daughter's condition. The IJ denied relief in 2018, based on a finding that Mr. Martinez-Baez had failed to establish the requisite 10 years continuous physical presence in the U.S., and that he had failed to establish hardship to his U.S. citizen daughter if he was removed to Mexico. The BIA affirmed. The Seventh Circuit reversed. First, it held that it had jurisdiction to review the issue, no small thing, due to INA Section 242A2B, because Mr. Martinez-Baez presented a sufficiently legal question, quote, whether an IJ commits error when he fails to make an express credibility finding and then holds that gap in the record against the applicant, end quote. Framing on appeal matters. Here the Seventh Circuit held that such an error goes, quote, to the procedural sufficiency of the hearing, end quote. Namely, Mr. Martinez-Baez testified to his presence and work in the U.S. since 2000. And he explained that he lacked documents to prove it because they were under a false name, and he may have lost them. Although immigration law allows an IJ to require corroborating evidence, quote, when a credibility finding is inextricably intertwined with the IJ's ruling on the need for corroborative evidence, the agency must consider the applicant's credibility before ruling on the need for corroborative evidence, end quote. That seems to be a broadly applicable respondent-friendly standard, and it is. Quote, when an IJ says nothing about credibility, yet later based his decision on the applicant's failure to produce evidence supporting otherwise undisputed testimony, he commits procedural error, end quote. The Seventh Circuit would not, quote, squeeze a credibility finding out of the record, end quote. And without an adverse credibility finding here, the IJ's requirement of further corroboration of the 10 years physical presence seemed to actually be a way for the IJ to try to find Mr. Martinez-Baez not credible without expressly stating so. And this an IJ cannot do. So the Seventh Circuit could not rely upon the IJ and the BIA's finding. Turning next to extreme hardship, the Seventh Circuit could review the BIA's finding because Mr. Martinez-Baez argued that the IJ made a procedural legal error when the IJ, quote, failed to recognize the existence of an entire swath of evidence that was pertinent to the hardship issue, end quote. Framing on appeal matters. Here, according to the Seventh Circuit, the IJ and the BIA erred by making contradictory findings, both between and within themselves, and mischaracterizing the testimony of record. The Seventh Circuit also relied on Wisconsin's standard for a child to even get into the IEP program, which requires a, quote, significant, end quote, auditory, speech, and comprehension impairment. Facts that were completely ignored by the IJ and the BIA. Kudos to Mr. Martinez-Baez's counsel for relying on undisputed and, quote, disinterested evidence, end quote, produced by the Wisconsin government itself. And finally, since it was unclear whether Mr. Martinez-Baez's daughter would actually remain in the U.S. if he was removed to Mexico, the IJ and the BIA erred by requiring that Mr. Martinez-Baez show that his daughter could not obtain a comparable treatment in Mexico, because again, she might remain in the United States. Mr. Martinez-Baez, therefore, gets another shot. Here's a short quote and a jurisdictional teaser. Succinct quote for your corroboration appeals, everyone. Quote, if the IJ makes no express finding on the point, then a rebuttable presumption of credibility arises, end quote. And finally, perhaps good things to come for Seventh Circuit practitioners on jurisdiction. This panel noted that the Seventh Circuit does not view mixed questions of law and fact as, quote, questions of law, end quote, over which INA Section 242A2D provides courts jurisdiction to review, notwithstanding the jurisdiction stripping provision at Section A2B. The panel in this case, however, noted that it was a, quote, serious question, end quote, whether its prior precedent divesting it of jurisdiction remains good law in light of the Supreme Court's decision last year in Guerrero-Lasprilla v. Barr, which had analyzed a companion jurisdiction stripping provision. This Seventh Circuit panel didn't need to answer the question here, but if the Seventh Circuit eventually finds that Guerrero-Lasprilla now provides it jurisdiction over mixed questions of law and fact previously precluded by Section A2B, it would create or at least enter a circuit split with the Fifth and Tenth Circuit post-Guerrero-Lasprilla. More to surely come. And that is Martinez-Baez v. Wilkinson. Finally, in a case straight out of a 1980s John Candy movie, we have Tomczyk v. Wilkinson, published by the Ninth Circuit on February 3, 2021. This is a case about Canada and reinstatement. Judge Bybee dissented respectfully and emphatically. Mr. Tomczyk is from Canada and was excluded from the U.S. in 1990 when immigration court was still compartmentalized into exclusion and deportation proceedings. Exclusion proceedings covered non-citizens trying to enter the U.S. and contained many of the provisions currently reflected at INA Section 212. Deportation proceedings were for those individuals already physically present in the U.S. and contained many of the provisions currently reflected at Section 237. Mr. Tomczyk was issued a final order of exclusion at the Canadian border for not having proper documents to enter the U.S., and due to a controlled substance conviction in Canada from 1971. Upon his exclusion into the dire Arctic forest of Canada, former INS provided Mr. Tomczyk with a document that had a warning that said that he'd be subject to criminal penalty if he attempted to re-enter the U.S. within 1 year. But in accordance with the law at the time in 1990, the warning didn't say anything about entries after 1 year. Over a year later, in July 1991, Mr. Tomczyk re-entered the U.S. without immigration documents. But he claimed in this case that he was in a car that was waved through by an immigration official at the time. ICE learned of him over 2 decades later, following a DUI arrest in 2016. DHS then issued a document reinstating the 1990 order of exclusion, which it's allowed to do under INA Section 241A5 if a non-citizen with a final order has entered the U.S. illegally. If a final order is reinstated, the non-citizen is pretty much summarily removed from the U.S. without a hearing before an immigration judge. They can't apply for any relief except withholding of removal and protection under the Torture Convention. And so they can't, as Mr. Tomczyk wanted to, apply for non-LPR cancellation of removal based on the harm his removal would cause to his severely disabled U.S. citizen spouse. Mr. Tomczyk contested DHS's reinstatement order, which it appears, and at least in the Ninth Circuit, skips all the other tribunals and goes straight to the Circuit Court. And in this case, the Ninth Circuit vacated the reinstatement order and remanded the matter back to DHS, based on a finding that Mr. Tomczyk did not enter the U.S. illegally in 1991, as that term is understood under INA Section 241A5. Go on. Quote, "We hold that illegal reentry under Section 241A5 requires more than mere status of inadmissibility," end quote, at the time of reentry. Relying on prior precedent, the criminal illegal entry provisions of the INA, and the absurd results of holding otherwise, the Ninth Circuit held that whether DHS can reinstate a prior order of removal depends on, quote, "the manner and circumstances of entry or re-entry," end quote, and that essentially a procedurally valid admission, like a waive-through, lacking any fraud or, quote, "some form of misconduct," end quote, on the part of the non-citizen, is not an illegal re-entry that can serve as a predicate for a reinstatement order. Boom. According to the Ninth Circuit, this decision aligns with at least dicta from the First Circuit. So, absent fraud or some form of misconduct on the part of Mr. Tomczyk, DHS cannot reinstate the 1990 order of exclusion. Congratulations, Xavier Gonzalez of Las Vegas, Nevada, for petitioner. Just 2 words of warning, though. First, although this decision is great for non-citizens, it's also heavily fact-specific. It seems to me that if your client has done anything wrong at the time of the second entry, or if, unlike with Mr. Tomczyk's 1990 exclusion order, the exclusion period was beyond 1 year and within the time period of the re-entry, this decision likely does not help your client. But that doesn't mean you can't argue it. And second, as this may be my only chance on the podcast, an apt word of warning from Canadian Bacon. Quote, "The Canadians, they walk among us. William Shatner, Michael J. Fox, Monty Hall, Mike Myers, and the late Alex Trebek. All of them Canadians. All of them here." End quote. Indeed, apparently they do. And that is Tomczyk v. Wilkinson. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.